Yeah, I'm real familiar with that court case. I didn't mean to interrupt. I just want to ask real quick. So you cite the Prince versus Massachusetts.
Prince versus Massachusetts in
Right.
1944. What it was
Right.
is it was, I believe it was a Jehovah's Witness parents who were having their daughter hand out pamphlets on street corners. And the case, the court stepped in for some reason and it went to the Supreme Court. But that was the ruling, is that the parents can be martyrs, but they cannot martyr their children. And they cannot expose society or their child to a communicable disease.
And I understand that. I guess, the concern is that my comment that was never really addressed is that currently we have the medical profession with a license to kill. I mean, there's no prosecution of all the deaths that they have in medical profession.
Well, there's civil liability. Like
Very little.
Clearly, if a doctor intentionally causes a death, there's going to be a prosecution, right? And clearly, in the cases of medical negligence and gross negligence and those sorts of things, there is a medical malpractice statute in Idaho now. Idaho has all types of weird things with that statute, like limiting your recovery and all of that, but it does exist. And so to the extent that there are legal mechanisms to prosecute either civilly or criminally doctors who act improperly, that framework does exist.
Yeah, it's just
Okay,
it's not used, certainly, unless you go, I mean, there's a huge pages and pages on the internet of malpractice attorneys in the state, and there's no mechanism for holding them, I mean, there's, for like the numbers, the annual numbers of medical errors in the state, there's not a real clear tracking.
Well, it is.
Just like with your situation. I'm
It
just
is
saying,
a truism that I think the number is like 2% of people who are the victims of medical error actually do sort of go bring a lawsuit. I don't know how much of that has to do with the high number of settlements in those type of cases. I feel like a lot of times for people who get an attorney, they're sort of signing papers in the hospital saying how you won't sue and you're just going to take the check. So there's a fair amount of that, and that's something that's just a truism of our American legal system. Over 90% of criminal and civil cases settle. We're just very litigation adverse. But I think, again, there is a cause of action for medical negligence that exists in every state. Now, there may be reasons why people don't pursue those causes of actions in proportion to the actual medical errors, but that framework does exist, whereas here we're talking about a framework that just does not exist at all.
Okay, and I think we have another question.
One thing I want to address about that, though, it's like the statistics for Idaho were 3.37% of Idaho deaths during the decade from 2002 to 2011. It was 3.37%, and that's from all causes. That includes medical neglect, stillbirths, natural causes, everything. And the Followers of Christ Cemetery, that's 10 times higher. The death rate is 31% because these children are not getting any care.
So, assuming a judicial remedy is possible in this issue, the list of people here withstanding to bring this case seems incredibly narrow. So, under what circumstances would you realistically see this ever brought?
Yeah, that's part of the difficulty too, right? It depends on which statute, because one statute really talks about this as sort of a bar to a prosecution. So with that statute, I could see a prosecution being brought. For whatever reason, there's an investigation. The coroner says, we're not so quite sure that this is a faith healing issue. Maybe it's something else. And the parent's liable. So there's a prosecution law. What that parent could do is bring the statute as a defense. And that could cause the court to really sort of interpret the validity of the statute. That's probably the number one way I see it going, because in most cases the child has already died, and therefore, dead men have no standing in most cases. And so I see it being very difficult for a child to bring a lawsuit, but I could certainly see a prosecution of a parent and that parent seeking to bring the statute as a defense. That reaching the Idaho Supreme Court, and through that mechanism, them interpreting the scope of the statute.
Now, the one question I do have, the first bill in 2014, John Gannon brought forth, it was just an amendment that stated that the parent was not negligent if they used spiritual means alone, unless it caused death or permanent disability to that child. Now, if you amend one statute for negligence and you leave that language in 3 others, is that going to cause even more confusion?
Yes.
So my response to him is that we need to either amend all 4 statutes to include that language, or we need to just remove that one sentence, because removing that one sentence puts every parent in the state of Idaho under the same laws. There's no get-out-of-jail-free card if your child dies without treatment. You will be treated the same way as any other parent would be right now. These laws don't protect you. They have nothing to do with alternative medicine, vaccines, or anything else. They only deal with people that use spiritual means alone. And it also states that you have to be a member of a church that practices that method alone. So if you're a Catholic, if you're Mormon, it does not cover you. If you're atheist, it does not cover you. These laws are discriminating against every parent in Idaho except members of this little Finke Lake community.
Hi, I just want to thank you guys both for being here, but I specifically wanted to just address something to Linda directly. I wanted to thank you for sharing your story. As someone who grew up in a very similar church, I know what it's like to not have a voice, and I want to thank you for speaking for Idaho's forgotten children and working so tirelessly to save them. I also want to just take a moment to recognize the pain and suffering that you went through growing up in this faith and the pain that you carry with you every day. I think I can speak for most of us here tonight when I say that I stand with you and the children who are not shielded from harm, but are harmed under these religious shield laws. I challenge everyone here tonight to share this issue with their friends and family. It's on us to speak up and to speak out. And here's my question: what can we do? How can we make changes?
You have to get involved. You've got to get involved with your legislators. We have to have a strong Republican legislator that's willing to stand up and say enough is enough. We have to protect these children. Until we have that, these kids are going to continue to die. These children, the headstones, I'm related to almost 100% of these children. This is my family that's doing this. It was my family, my ancestors, that started this religion. I'm related to the people that are running these churches. It's not easy to stand up against your family and against everything you know to do this. My family has completely disowned me except for the children that I was able to help get out of it. You know, this is not a loving religion. It has destroyed families. I've watched one family after the other be destroyed because they shun their children when they try to leave. If you speak up against the church, you are ostracized, you are shunned. My nephew spoke up against my brother when he went to the hospital. He says, "Why is it okay for you to get treatment and Stephen died without any care?" The answer to that was my brother and his wife taking all of my nephew's pictures off the walls, cutting them up, putting them in a box, mailing them to him in Washington, and saying, "You're no longer my child. You don't exist."
For those of us who do want to write letters to our legislators and get involved, what would you say are the most important things we should bring up in those letters? What, for example, are some of the numbers and some of the facts? You mentioned the 31% of deaths in those years statistic. What are other statistics we can use and as wording in those letters?
Out of the 210 children that are buried in Peaceful Valley Cemetery, 144 of those have been buried since Idaho passed their laws in 1972. 70% of those children died after these religious shield laws were introduced. Idahoans don't like the federal government telling them what to do. These laws were forced on the states in the 70s by the Nixon administration. Aldermen and Ehrlichman were members of the Christian Scientist Church. These were known as the Christian Scientist laws in Idaho when they were passed. They were passed with little to no discussion. They were essentially rubber stamped and pushed through. The federal government required every state in the United States to have some form of these religious shield laws on the books in order to get funding for child abuse programs. In 1983, Rita Swan established CHILD, which is Children's Health Care as a Legal Duty. Her and her husband have fought since 1983 to change these laws nationwide. In 1983, they petitioned the federal government. The federal government removed the requirement to have these laws, but they left it up to the individual states on whether these laws were to remain on the books or not. Idaho is one of them that left them. Most of the states had these laws that remained. Idaho is only one. I think there's 6 more that have the statutes for felony manslaughter, neglect, and non-support. Idaho has the worst laws in the nation. They also have the highest number of reported faith deaths.
I think we have time for one more question. Maybe 2.
I was just wondering how you plan to show intent with, say, you need to have a criminal charge against these parents. And so how, is there a framework in place to show intent with Idaho?
Yeah, from a criminal standpoint, yes. And you can use things like circumstantial evidence. Oftentimes in abuse and neglect cases, there's sort of a medical, sort of a doctor looks over the child, there's sort of an expert report of the cause of injury, that sort of thing. And so I see that framework sort of being easily applicable here. But like I said, part of the problem I have, even assuming the law stays the same, and assuming that for whatever reason there's a prosecution, and maybe there is some question of whether the parents' methods constituted spiritual means or prayer. Well, I think that there is a problem with the state trying to interpret what that means, because the U.S. Supreme Court has already ruled that you are not allowed to probe into the veracity of one's belief. And so I can say whatever I want to say and call it prayer, and guess what? I got the right to do that. And so in some sense, I think even trying to prosecute a case under the current statute could lead to constitutional issues for the state, because I don't know how you don't get around saying something's prayer versus not prayer, something's spiritual means versus non-spiritual means, especially if the state is seeking to bring a prosecution. And so I think that that's why I think that those words as they're used in those statutes are very troublesome. Even where a state wants to conduct a prosecution, I think to prove their case, they would have to violate the Establishment Clause. So I'm at this weird sort of place here where I think the statute itself violates the Establishment Clause. I think actually trying to implement the statute violates the Establishment Clause, and I think this, the failure to even investigate or anything constitutes an Establishment Clause violation, because you're preferring religious belief over non-belief. And so I think the statute, I think it needs to be amended or repealed.
The thing is, in a child abuse or a neglect case, religion should never enter into the investigation at all. Every child death should be investigated the same way. every child has the same value. There's no reason that these children should not have the benefit of an investigation or an autopsy. There's one case in Canyon County that still bothers me today. I have a coroner's report for a 31-day-old baby. There was no reason this child died. The child was laying on the mother's chest, and she said it grunted. She thought the baby was hungry, and so she was going to nurse it. Well, they discovered the baby had quit breathing and had died. Detectives were called in because the coroner was not available. The grandfather and the father challenged the detective and said, "You will not take this baby for an autopsy unless you do it by force." The detectives called the deputy coroner of that county. They called the prosecuting attorney's office of that county. They were told to stand down and to leave the premises, leave the body. That child was never examined. It was never investigated. They said it was because of their religious rights. They didn't want the autopsy. I have several coroner's reports where autopsies were done on followers of Christ child. That is not in their tenets. There was something wrong with that baby that they did not want it to be seen.
So is it standard operating procedure for Idaho to do autopsies on every other child?
There was a law passed in 2005, the coroners, the requirements for coroners were amended. And as I understand it, it says that medically unattended deaths are to be turned over to the law enforcement of that county or jurisdiction. There's one little statement in there that I'm not sure of that says it cannot violate the tenets of a religion, but that's like on the fourth one. This is a fairly new statute, so I'm not familiar with it. I'm not an attorney, of course. But my understanding was that coroners are actually required to turn over every medically unattended death to law enforcement. That's not being done.
And there are usually exceptions there if, the doctor knows that maybe there's a terminal illness
Yes.
and that sort of thing. But I think in general, you're right. If there's no medical sort of...
If there's no
activity
medical
there,
reason for that child to have died, there's supposed to be an autopsy.
Yeah.
It's not being done.
Yeah, and no documented history of medical issues. And that sort of
So why all the amendment if we just need to follow the law that's already in place?
Because there's an exception
There's a
for-
religious exception to it that's giving the coroners a way out.
Even though circumstantial evidence and confidential doctor's reports aren't really admissible, right?
Exactly.
Okay, it's 5 minutes too, so we better wrap it up. Thanks everyone for coming tonight, and thank you especially for your questions and comments, and thank you to Linda and Shakira. Thanks.